Welcome to Small Practice Support Information Session number 72. In this recording, Gavin Sheridan talks to Justin Purcell about case management and Superior Court rule changes.
You're all very welcome to a Small Practice Information Session with the Law Society. I'm joined by Gavin Sheridan from Viz Legal, and today we're going to be discussing case management. What do recent support court rule changes on less orders mean for practitioners? So you're very welcome, Gavin. I'll stop sharing and allow you to open up there, and away you go. If anyone wants to ask a question, if you could, we'll take it on the chat. So over to you, Gavin.
Thanks a million, Justin, and hello to everybody and good afternoon. So my name is Gavin Sheridan, as Justin said. I'm from Viz Legal, and I suppose the thing that's come up recently is the changes to the Superior Court rules around on less orders and default in motions in the rules of Superior Court. So this commenced on the 13th of November, and it's from the SI 490 2021. And I suppose in summary, and there was a very good blog post by Kevin Healy in Common Calher Tobin recently about this. And I suppose the summary version is that that the judgment be entered in a motion for a judgment of default of defensive statement of claim, except where justice requires an extension of time. And in the event the court shall make an unless order, just requiring one court hearing only. So I suppose what practitioners have said to me is they have to be really on the ball when it comes to timelines and deadlines when it comes to unless orders. And then that the time allowed for the delivery of a statement of claim or defense shall be 8 weeks in all cases. The requirement to deliver a 28-day warning letter prior to bringing an application for judgment default of pleading, and that a plaintiff be required to serve the motion on the defendant in all applications for judgment in default of appearance. So our customers have said to us that being on top of their high court cases is extremely important, because you could find yourself in a situation where an unless order has been given and you might have missed your day. So, or missed your chance. So some of the tools that we have started building, and I'm going to share my screen with everybody now, so you can see how we've tried to address some of these issues is, and you should be able to see my screen now. Justin, you can see my screen there now, okay? So what you'll notice is that we've, I suppose, built a system that tries to keep on top of the High Court diary system itself. So that would, in a case where you have a case that you have on, and it's one of your cases, you might want to keep an eye on it, because you might want to get notified when a new filing, list, or order happens in that case. So, for example, recent High Court cases filed, say yesterday, would be these cases, and let's say one of these, and I'll pick one at random, might be this one. If I follow that case inside our system, that means that you will get notified when a new filing, list, or orders happens. Is obviously you need to keep an eye on motions. So how you keep on top of cases is, I think, certainly our customers have said to us, is becoming more important because of these new rules. But what I'd also say is that what our customers have been saying to us is the rules themselves are constantly changing, and the practice directions are constantly changing across the courts. So it's not just the rules of the Superior Courts, which is what I'm talking about here, but also the district and circuit court rules. So what we've tried to do to address this is that a lot of practitioners and our customers have said to us that sometimes practice directions can get published and you might miss them on the court's website. Sometimes rules can get amended and you might not be aware, or might be aware long after the fact of it happening, because people are busy and there's a lot of things moving around. So what we've done to try and address this is to consolidate the rules and practice directions into one common system. So here what you can see is a list of all the rules and practice directions ordered by the date they were changed. The most recent change being in the Superior Court's the Wards of Court Order Minors. Order 67 was amended just a couple of weeks ago. Defense and counterclaim, and then all of these, Order 21, Order 27, Order 13, Order 23, Order 63, were all, and Order 20 were all amended as part of this change towards unless orders and default motions. So we have consolidated all of these rules back to inception. So the original rules of Superior Courts go back to 1986, I think it is, and we will show you the consolidated version of the rules, the last date on which that rule change happened, a link to the court's version of the rule, the original SI the rule was based on, when it was amended, and then subsequently when it was substituted, which is the most recent substitution that happened for the defense and counterclaim rule, and then our version of the consolidation of the rule in full. there's been several kind of things we've spoken to practitioners about how to improve these, because there's been a lot of complaints about how they're used and how you use them. One thing is things like the indents of the rules being appropriate and being in line, so easy to read. The links to things like other orders that are mentioned in the rule or subsections of legislation. So to save you to click or to the new tab or having to Google something, if it says the Common Law Procedure Amendment to Ireland Act 1853, Section 145, you can just click that and we'll bring to Section 145 to that piece of legislation, saving you the hassle of looking for it when you're looking at the rules and so on and so forth, when you're looking at Section 32 or Section 58 of the Consumer Credit Act 1995. What we're trying to do here is, can we give the consolidated version of the rules and links to anything that's relevant that flows from those rules over time, an easy way to look up a rule? And what you might have noticed as practitioners is, when it comes to the rules of practice direction part of the court's website, they can sometimes be either out of date, or there can be a lag between the rule being amended or coming into force and then the actual rule appearing on the court's website. So for example, we've noticed that, say, for example, it's the district court and it's Order 38 miscellaneous matters. This was fully substituted on June the 2nd this year. It's been amended a lot since 1997, but the full substitution came into force in June. Now, we've done the job of trying to consolidate this and showing you the full consolidated version, linking to everything that needs to be linked to and indenting it to make it as easy to read as possible. But on the court's version of the website, it's still the earlier version of the rule that was amended 5 months ago. So we're trying to make sure that these are as up-to-date as possible. So what we do is, for the several hundred barristers who use us every week, plus our solicitor customers, we send an email out regularly, like, I mean, on average 3 to 4 weeks, saying that a rule has been amended or a practice direction has come into play, or a practice direction has been amended either, because this happens relatively frequently, as practitioners would be aware. And then giving the access to the consolidation of the rule and practice direction on your desktop or on your phone if you're out and about, or on your tablet, is what we've focused in on from one point of view as a feature of our product. And our feedback from our barrister and solicitor customers has been that this is extremely handy, extremely reassuring to know that even at a minimum that the rule has been amended on a given date, and that they can go and investigate themselves, but we will give our version of the consolidation on top of that. And that would apply for these recent rules changes. So when I'm looking at the recent rules changes to the superior courts, it would be these default of appearance and statement of claim, and the master of the High Court was also slightly amended. So if it's statement of claim, substituted by SI 490/2021, came into operation on November the 13th, which is a Saturday a couple of weeks ago, links to everything that you need, Article 80 of the GDPR, Section 117 of the Data Protection Act, and so on and so on. We've got extremely good feedback from all of our customers, which includes smaller law firms, it includes the largest law firms, and it includes barristers as well, who said that this is an extremely handy feature, both checking the consolidation and getting the alerts to the changes. But going back for a second to this idea that you might have a High Court case on and you'd like to track it and get notified. If I go and find one of my own cases, say Mustafa versus Twitter, and it's Ronan Daly's representing the plaintiff, just by clicking follow, I'll subsequently get notified of any notice of court motions coming in, the date it was sent in, any affidavits that were filed by yourselves or the opposing side, changes to the listings, the date, the future date on which that listing is happening. In this case, it's 31st of January. It's listed for Chancery Court 5 motions next month. And as you track those cases, and it could be your own cases, or it could be cases that you're interested in, they go into the My Cases tab, and then you're tracking all of the cases for this idea that you need to know the status of the High Court case as soon as anything happens or changes, because then that sets into motion in your head the clicking clock, the ticking clock that can exist when it comes to this new rules change. So I can see, for example, here, if it's an Irish case such as Albatrans versus Allied Irish Banks, you can see here this is a new case that's been entered, and you can see the changes that are happening. It's Fernley Residents Association. You can see the history of the case. So in this case, it's Fernley and resident by FB Logue, and Albert Null on the other side. You can see recent activity is that on the 14th of December, on the advance warning list in Massachusetts Howland, 73 on the list, it's coming up. You can see the previous history of the orders as well, and that were perfected on given dates. And likewise, you may want a copy of the orders. So what we've built is this idea that instead of you having to write an email each time you need a copy of the order, as representing one side of the case, you can simply click request copy order, and then we will draft a pre-filled email in Outlook that you can then send to the registrar to get a copy of the order. Again, the idea here is to save you clicks and save you the hassle of typing out the same email over and over again, looking for copies of orders. We've got amazing feedback from smaller firms in this in particular, because this can be a very rote task that has to be done over and over again. If you can make it a couple of clicks to send that email, it saves time for the business and hopefully saves money as well for the team. I suppose the biggest thing that also relates to kind of how these rules change over time, both not just the Superior Court, but also the Circuit and District Court rules, is how you keep on top of court dates. And the feedback from speaking to lots and lots of smaller firms is that the Circuit Court lists can be incredibly difficult to keep on top of. And certainly some of our customers have really got serious issues with how they have to manually maybe check the Circuit Court lists, how they might have to check the provincial PI lists, how they might have to check things out. We've tried to build systems now that have automated a lot of that. So I could jump into my cases here. And this is, again, is a list of the cases I'm tracking in the High Court. But on top of that, seeking to layer on the calendar of your firm so that in the Circuit Court, you would extrapolate the future court dates for your firm based on us checking all of the Circuit Court diaries to detect your firm's name and then extrapolate out future court dates. So for example, on the 9th of December, tomorrow, in Tralee, you've got this case on the county registrars list. In Tralee, you've also got this case, Shine versus Governor of Cork Prison, Stephanie Regan versus Cork City Council, in front of Judge O'Donoghue, number 4 on the list, and so on and so on, where we will detect if where a firm name is mentioned inside a Circuit Court diary, then match it to that customer, and then extrapolate out and give the future court dates, as well as warning emails saying, here's how you need to here's where you need to be in the country, at what time, and hopefully in front of what judge it's going to be. Because what our customers have said to us and what solicitors have been saying to us is going in and checking all of the Circuit Court diaries to see if any of your cases are on or what's going on with them is a time-consuming and onerous process. We're trying to make that whole process as efficient as possible, but not only for the Circuit Court. On top of that, we're looking at things like the High Court diary, which includes advance warning and serum, Mr. Justice Holland, on December the 14th, 73 on the list. So how we then extrapolate out is a fairly, I think as practitioners might understand, the High Court record system, which has recently been changed by the Court Service into the Seession system, as well as the diary system, the High Court diary system, which is the long list of cases, including provincial PI callovers. We've essentially automated that. We've taken all of the diaries and the High Court record system, amalgamated them, then extrapolated out who represents who on each side, and then extrapolated from that where the practitioner is supposed to be at what time, in front of what judge, in what court in the country, regardless of whether it's the Circuit Court or the High Court. And now we're also adding the Court of Appeal and Supreme Court, because as you can see here, Supreme Court for hearing is on the 14th of December in Right to Know versus Commissioner over 2 days. So the pain here that we're trying to solve is if you have rules changes like the ones that are the subject of this talk, you need to know what the consolidation of the rules now are, now that they've been amended, not just in the Superior Court, but in the Circuit and District Court as well. You also need to know what's going on with the case, in particular the High Court case, because you need to know when other stuff is happening, such as motions being entered. So we've tried to then build that tracking system so you can do that. And then how you then know from more superior courts, if you do end up with the Court of Appeal, Supreme Court, how do you track those lists? Because at the moment, all of those are manual processes. So I think for us, it's building that alert system based on your firm is the key thing, is that we can already extrapolate out by knowing what firms are on each side in each case, what your future dates are. Another big complaint that solicitors and barristers have said to us repeatedly, and that we're solving with some of the features of this, is as and when judgments appear, say a High Court judgment comes out, a practitioner will need to get alerted when specific types of judgments come out. And we've spoke to a lot of solicitors and barristers about this problem. The consensus solution was, could you please build a system that would allow us to get alerted when a phrase was used in a judgment, such as road traffic accident, or freedom of information, or data protection, or any of the areas of interest that you as a practitioner or as a firm are focused on. And what we've done to do this is essentially to say, if I was to say the phrase data protection and do a search for that as a phrase using double quotes, and say, well, when's the last time this came up? I could say, well, in judgments in Ireland, the last time this came up was in Brophy versus Independent News and Media, which is the red flag case involving the Irish Independent. That came up in the context of that judgment that came out just last week. And it's 2021 IHC 713. And then I've also seen that, well, that phrase has been used in 298 court judgments, 64 Court of Appeal, 36 Supreme Court judgments, or Humphreys has used that phrase the most in his judgments. But likewise, I'd like to know that next time that phrase is used. So I've got my phrase search here for data protection. I've got my filter set to judgments in Ireland, and I can press start. And the key thing practitioners have said to us, notwithstanding that you need to be aware of changes to rules and practice directions, is that you need to be aware when new judgments appear. And what I would really, and what practitioners want really is not just any judgment, judgments that contain specific words or phrases, and maybe even judgments that contain specific words or phrases from specific judges, which you could also do and say, well, I only want to know when Gareth Simons mentions planning, which is a lot of his judgments. So you could have a multiple alert system where you're getting all these alerts, and they would end up in your My Alerts tab. And also part of this is also say for example, tell me when COVID is mentioned as a word in any future WRC or Labour Court decision, which right now is really important because how the WRC and Labour Court are interpreting how employers are how COVID is impacting employment decisions is extremely important for employment practitioners. So for example, December the 8th, McCafferty versus Society of St. Vincent de Paul, 8th of December, where was COVID mentioned in the context of this? Sometimes it can be mentioned in a very specific way, but in this case, the shop was closed due to COVID, and then they're going through the respondent's case and then ultimately making a decision. Getting alerted to those things can be quite important depending on your area of practice. But again, you could do this across not just WRC or Labour Court decisions. You could do this to Court of Justice decisions, to Irish judgments coming from the Irish courts, English judgments from the English courts, English employment decisions, or even US Supreme Court decisions. Like, for example, frivolous and vexatious would be one of my favorites. When do these things come up? Sheridan versus the IB, no relation of mine, it's coincidence. Determination of the Supreme Court there dealing with a matter of frivolous and vexatiousness, and same with these cases as well. And this is you can see this is an English Welsh High Court decision. This is an Irish Court of Appeal decision. This is a WRC adjudication. Building up these alerts, it's one of our most popular solutions for barristers and solicitors is I just need to keep on top of these phrases. Please send me an email every morning whenever a judgment or decision is published that contains that phrase. And I think building that alert system on top of consolidated rules of practice is getting alerted to changes to those, on top of trying to track those high court cases and making sure that you can see the dates that stuff is coming in and when deadlines are kicking in when it comes to default or on less orders. So all of those mixture of things together, we think, given these new Superior Court rules changes, are really powerful for particularly for smaller practices who may have a high court business, but also have a busy circuit court practice and need to know when their court dates are coming up, which goes to the case management point Justin was making at the start. So I don't want to delve too much, just to suffice to say, I won't go into the depths of how we solve several other problems that exist within this area. We are very keen to talk to more smaller practices in particular, because a lot of what we've built here is designed and priced with smaller firms in mind, who we really want to give powerful tools. Our customers include the law library and hundreds of barristers that exist in the law library, but also larger firms in Dublin, smaller firms, single practitioner firms are also our customers in Cork and in Limerick and in Dublin. So we're always keen to talk to more smaller firms, particularly because we think that smaller firms have been underserved by powerful tools. I think sometimes what happens is technology companies go near they just want to go near the big firms and they don't listen to the smaller firms. We want to talk to smaller firms and we want to make sure that they have the best tools that exist, and also continue talking to smaller firms about how we continue to improve our product. What more could we do? How could we add more features that would serve smaller firms on a day-to-day basis that build up this capacity to do more business, hopefully to build a bigger practice, but not necessarily through hiring more people. Maybe you can have a busier practice just using technology and being efficient in how you approach litigation, for example, or if you're involved in court actions. What's the most efficient way you could do that, and what tools would you need, and what features would you need to be able to achieve your business objectives? I'll leave it with one thing because I have a couple of minutes. One thing I would say in addition, and it's kind of a common problem that barristers and solicitors told us about when we were building some of these tools, is let's say a determination comes from the Supreme Court, and in this case, it's John Sheridan versus AIB. Practitioners said to us, sometimes you say, well, that's an important decision. I need to keep it, or I need to store it somewhere. Sometimes people would download it to their desktop and maybe put it in a folder and call it the folder important decisions. And sometimes people would print it out and put it in a folder. We spoke to a lot of practitioners of what would be a better solution potentially, and they kind of agreed that a bookmarking system would work. So let's say this was an important decision to me, and I needed a quick way to store it and look it up. I would just go bookmark and save it and say, well, this is a COVID, let's say it's a COVID related decision. Then that will go into my bookmarks, and I would build my bookmarks over time inside the system. And then I'll be able to look those up really, really quickly on my phone if I was in court or if I was in the office, look it up, and then be able to find those things really quickly. Again, trying to save time, save labor, and make sure everybody is happy to access that information as quickly as possible, because it should be, we think, at your fingertips. Even if you're down in the forecourts and you're a barrister and you want to look up a judgment really quickly, you're like, oh, that's the one I was looking for because I tagged and saved it earlier. No, it's not that it's on a computer at home that I saved it to earlier. It's that it's always there in your pocket, or it's always there on your tablet or on your laptop. And I'll leave it there, Justin. I could go into all sorts of other details, but I think that's the clear connection I wanted to make there, Justin, is that the rules keep changing. Keeping up to date the rules is a task in itself, and the practice directions, and they keep changing. But also keeping on top of the cases that are flowing, as well as keeping on top of your diary, are all kind of, to us, interconnected problems that are worth solving.
Sure. Thanks, Gavin. Just, I suppose, if anyone wants to ask a question, we'll take it on the chat. I'll get started. This unless order that the Superior Court made, it was on November the 13th, I think. Like, what are the unknown sort of implications of that, do you think?
So from talking to our customers, which include like fairly high court litigation heavy practices, the consensus is that what could happen is that if you miss your chance, what traditionally would have happened before this came in, you might go down to the court and then ask the judge, look, we missed our date, or something has gone wrong, or the clock started ticking and we missed our window, and then you have to go back to the judge. What can happen in this case is there's a higher risk that the judge will just go, look, you've missed your chance, and that's it. And then you may have failed your client in that situation, because they're trying, the whole purpose for this, or the way the courts have said it, is the whole reason for bringing about this rule change is to try and make this process more efficient. So there's not a lot of things hanging around, that things get done and you move through stuff. And obviously the consensus as well from our customers is that there's a lot of backlog that has to be cleared because of the pandemic last year and this year. And they're trying to streamline the process here. So how the process is streamlined is you have to be on top of your timelines when it comes to this. So as I said, the 28-day warning letter and the standardized time allowed to deliver certain pleadings is a positive development, as the blog post said last month. So, but you have to be acutely aware of the impact of the introduction of a mandatory unless order in motions for default of pleading. So particularly defendants, as they are most often the subject to a motion in default of pleading. So you have to be on the ball when it comes to the timelines, given these new rules.
Okay, very good. And so what has typically been a sort of an onerous list, check. Digital technologies have allowed for sort of the automation of what is quite a routine task, but yes, information coming from a variety of sources. So this is a solution to that. So what I know you gave some intonation around the typical company reasons for signing up, or who they are. Do you want to just go back over that for a second, and then maybe move on to, like, how accurate is this, if you don't mind me saying, like, how accurate are you getting a feed? How do I know what you're giving me is watertight, or do you stand over it, or, you know? Yeah,
so the way a typical customer for us could be Ross McMahon in Limerick runs a small firm in Limerick. He does district circuit and some Superior Court work. We would automate his calendar for him, so we would give him his future circuit court dates, his future high court dates automatically using our system. He would also get the alerts around rules and practice directions changes, which helps him keep on top of the game as well. But similarly, Coleman Legal in Dublin would be another customer who would be a very heavy PI and medical negligence litigation firm. Their entire team would use us for accessing their future court dates as well across the circuit, High Court, Court of Appeal and Supreme Court. So they would be kind of the two types of customers that would use us in the context of particularly rules and practice directions changes and viewing the consolidation and tracking their cases and getting the alerts to the future dates. In terms of what we stand over, so like all businesses, just like Westlaw and other services that provide things like the consolidated rules, what we say is we go to inordinate effort to make the consolidations as accurate and up-to-date as possible. In fact, I'll often email all of our customers on a Thursday evening and the rule changes coming in the following morning. I'll say, just to let you know, this new rule change is coming into operation tomorrow. The proviso on that is we don't accept, just like Westlaw and the big guys, we don't accept liability for our consolidation not being accurate, but we do enormous amounts of work to try and keep it as accurate and up-to-date as possible. Including things like, we have systems checking the court's website for any changes in the character count inside a practice direction to see if it's been amended, because sometimes what can happen is a practice direction may be amended, but the court service may not publish that necessarily in a timely way on their website. They may not tweet it out. So we will have separate systems checking, not just the practice directions on the court's website for changes or for new practice directions or for amendments to practice directions. We're also checking Irish statute book all the time as well to see if any new SIs have been published that are amending any rules that are maybe changing the fees. Things like the licensing fees in the district court, they extended the rules on those for reducing the fees because of COVID. We would have sent out emails to all of our customers saying, look, this is a district court rule amendment has happened. It comes into operation today or tomorrow, and those practices are then all up to date. And what we've seen is that that's an extremely popular feature, because keeping on top, besides all the other things a small practitioner has to do, all the other jobs on top of all of this, keeping an eye on the rules of practice directions is just another job, the task that we hope that we can help with and give the practitioner that kind of the peace of mind that they need.
And how often do you update your rules, or how do you know that you're getting the latest?
So like we would update the rules and practice directions, I'd say on average every 3 to 4 weeks, because the courts are constantly, the judges are constantly changing the rules and amending them or introducing new ones, either because of European law impacting on the rules or on domestic law. And practice directions would be down to the judges as well. So we would say every 3 to 4 weeks, at least one rule or practice direction would be changed or introduced. And then we have automated systems that are checking independently where those things are published. And then we will by hand amend our rule as well to show you our consolidation of those. And then we would send out that email to all of our customers saying, there's a new rule or there's an amendment to rule, here it is.
Very good. And well, how do you cover both High Court records and High Court diaries? Or is there any area that you're not covering? I suppose is the other question.
So
is there any gaps in your outlook?
That's a very good question. So one of our customers as well is Ken Kennedy in Dublin, who do a lot of words of court work. And the words of court list is actually a separate diary inside the High Court diary system. This is very nerdy diary topic. But they came to us and said, look, you currently don't include words of court diaries in your system. And that was because words of court don't have a High Court record number because of the nature of the words of court list. Is there any way you could add them? And we did. Based on that feedback just in September, they said, look, we are doing a lot of word court work. If our name pops up as a firm representing a plaintiff or defendant in a words of court case, could you let us know when that list is published, and then also what our court date is? And we finished that work last month. But also it impacted on another customer like Mason, Hayes and Curran. So we try to constantly expand our scope. But right now, it's all High Court diaries that we can identify a firm name in it, plus the CSOL High Court search system together. Because what we've noticed, and practitioners will be aware of this, sometimes the common law motion or chancery lists on the diary side are out of sync with the High Court record search, which means that sometimes you can miss things and you can miss court dates. And another thing is the provincial PI lists contain setting down numbers, not the High Court record numbers. We do a job of matching the setting down number inside a PI provincial list, say for a call over, a virtual call over, and then match that to its respective High Court record. Then we match that to the firms on each side. Then we extrapolate that as a date that the people in that firm need to be aware of. So we do a lot of work in the background what you saw was kind of the simple view of what the outcome is, but all the mechanics, the technical engineering is all in the background of actually gathering all that data and then synchronizing it.
Listen, Gavin, we're out of time, I'm afraid. You've been a good sport today to bring us through this, what I think is a really growing area of digital automation, which really offers huge power to smaller practitioners in really getting a handle on these lists and making sure that they're up to date and some of the powerful access to information in a real time. So it's very exciting going forward. So thanks a million for joining us today. Hopefully you'll join us, all of you will join us next week when we talk to Anita Ellis, clinical lead with Legal Mind. And then there's a few dates there out in, dare I say it, January 2022. It just seemed like that was when we were going to be going to space on holidays in 2022 when I was in school. So not to be, I don't think, this year. But anyway, thanks everyone for joining us. We'll see you next week. Slán.